Greetings dear viewers. Today we will be discussing the lesson on mediation in consumer disputes. Mediation is a voluntary process in which a neutral third party facilitates or assists the parties to a dispute in arriving at a settlement. It can also be understood as assisted negotiation, and the dynamics as in negotiation also apply to mediation. According to Black's Law Dictionary, mediation is a private, informal dispute resolution process in which a neutral third party, the mediator, helps disputing parties to reach an agreement, but the mediator does not have power to impose a decision on the parties. The mediator is a trusted person who enhances communication between the parties by making them focus on their true interests and orients them to remedies and solutions. It is a confidential process, and any admissions, proposals or offers of settlement made during the process cannot be used as evidence in subsequent litigation or arbitration. Even the Honorable Supreme Court in Moti Ram versus Ashok Kumar 2011 held that in case of failure of court referred mediation, the report of mediator should only state that mediation was unsuccessful and should not disclose anything else. There are two models of mediation practiced throughout the world. One, facilitative mediation, and second, evaluative mediation. In the facilitative model, mediator endeavors to facilitate communication between the parties and helps each side to understand the other's perspective, position, interests and needs in relation to the dispute. In evaluative method, the mediator provides a non-binding assessment or evaluation of the dispute and suggests terms for settlement which may be accepted or rejected by the parties. Advantages of mediation. Mediation is a voluntary, participative and confidential process wherein parties get opportunity to present their case directly and have liberty to opt out at any stage. It is speedy, efficient and economical. The procedure is simple and flexible, and the parties have control over the process in terms of its scope and outcome. It helps to maintain, improve and restore relationships between the parties. It focuses on interests of the parties and ignores the inimical positions. It prioritizes on resolving the dispute in a mutually beneficial settlement. The parties are free to come up with creative solutions to the dispute. It is a fair process where mediator is impartial, neutral and independent person. It promotes finality and puts an end to dispute without scope for further litigation. In case of court referred mediation, the parties are entitled to refund of court fees. Now, let us understand the qualities of a good mediator. A mediator should be a person of honesty and integrity. He should be impartial and neutral towards the parties. He should be wise and understand the situation correctly and decide the right course of action. He should maintain confidentiality and transparency in the mediation process. He should have the expertise to understand the technicalities of the dispute. He should be courteous and shall respect the parties. He should be a good listener and shall assess the interests and needs of the parties by attentive listening. He should be patient, during conducting the mediation proceedings. He should have sympathy and empathy towards feelings and problems of the parties. He should shift the focus of the parties from positions to interests and guide them in reaching solutions. Now, let us understand the position of mediation in India. In India, mediation can be categorized as private mediation and court-referred mediation. Private mediation refers to a mediation of disputes where parties themselves go for mediation without reference from court. There is no law governing private mediation in India, and the settlement agreement is enforceable as a contract. If mediation is done in respect of a case pending in court, the parties may withdraw the case or report compromise and obtain a decree under Order 23, Rule 3 of CPC for a civil case, or compound the offence under Section 320 of CRPC for a criminal case. Court-referred mediation relates to cases which are referred by court for mediation under Section 89, Order 10, Rules 1A, 1B and 1C of CPC. It is governed by ADR and mediation rules laid down in the case of Salem Advocates Bar Association versus Union of India and shall be understood from decision of Supreme Court in Afcons Infrastructure Limited versus Cherian Varke Construction Company Private Limited, which deals with the issue. In the Afcons case, the Supreme Court has also pointed out that all consumer disputes, including disputes where trader, supplier, manufacturer, service provider is keen to maintain his business or professional reputation and credibility or product popularity, are normally suitable for ADR process. Now, let us look at the position of mediation with respect to consumer disputes. The Consumer Protection Act 2019, identifying the significance of mediation for consumer disputes, has specifically provided for constitution of mediation cell under the Act and statutorily provided for mediation as a mode of resolving consumer disputes. The Chapter 5 of the Consumer Protection Act 2019, consisting of sections 74 to 81, particularly deals with mediation. Apart from this, the Consumer Protection Mediation Rules 2020 and Consumer Protection Mediation Regulations 2020 govern mediation in consumer disputes in India. A consumer dispute means a dispute where the person against whom a complaint has been made denies or disputes the allegations contained in the complaint. In the context of consumer dispute, the word mediation means the process by which a mediator mediates the consumer disputes. Mediation in consumer disputes is carried out for any consumer complaints filed before the District Commission, State Commission and National Commission. The term mediator is defined as a mediator referred to in Section 75 of the Consumer Protection Act. Now, let us understand the procedure for reference to mediation. The Consumer Protection Act 2019 has introduced the provision where at the first hearing of the complaint, after its admission or at any later stage, the relevant commission can refer a consumer dispute for mediation when there is a scope of settlement between the parties. The parties are given a time frame of 5 days to accept or reject the process of mediation, as consent is vital for the reference to mediation. Further, the parties shall not initiate any arbitral or judicial proceedings in respect of a matter which is the subject matter of the mediation. However, on failure to arrive at a settlement by mediation, the Consumer Commission shall continue with the adjudication of the case. Now, let us understand the matters which cannot be referred to mediation. The matters relating to proceedings in respect of medical negligence resulting in grievous injury or death, matters which relate to defaults or offences for which applications for compounding of offences have been made by one or more parties, cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, and cases relating to prosecution of criminal and non-compoundable offences, and cases which involve public interest or interest of numerous persons who are not parties before the Commission cannot be referred to mediation. In any other case, the Commission before which the case is pending may choose not to refer it to mediation if it appears to the Commission that no elements of settlement exist which may be acceptable to the parties, or that mediation is otherwise not appropriate having regard to the circumstances of the case and the respective positions of the parties. Establishment of Consumer Mediation Cell. The state government shall establish a consumer mediation cell to be attached to each of the district commissions and the state commissions of the state, and the central government shall establish a consumer mediation cell to be attached to the national commission and each of the regional benches. Every consumer mediation cell shall maintain a list of empaneled mediators, a list of cases handled by the cell, a recording of proceeding. Every consumer mediation cell shall submit a quarterly report to the district commission, state commission, or the national commission to which it is attached. Empanelment of mediators. The national commission or the state commission or the district commission shall prepare a panel of mediators to be maintained by the consumer mediation cell attached to it on the recommendation of a selection committee consisting of the president and a member of that commission. The panel of mediators shall be valid for a period of 5 years, and the empaneled mediators shall be eligible to be considered for re-empanelment for another term. Also, each consumer commission shall invite applications from eligible persons for empanelment as mediators by publication of a notice in at least one English and one vernacular newspaper widely circulated in its jurisdiction. Eligibility for empanelment as mediator. Retired judges of Supreme Court of India, retired judges of the High Courts, retired members of a consumer commission, retired district and sessions judges, retired additional district and session judges, or other retired members of the higher judicial services of a state. Retired judicial officers having experience of not less than 10 years, an advocate with a minimum experience of 10 years at the bar, the mediators empanelled with the mediation cell of the Supreme Court of India, High Court or a district court. A person having experience of at least 5 years in mediation or conciliation. Experts or other professionals with at least 15 years of experience or retired senior bureaucrats or retired executives. Further, the mediators shall be given appropriate training in conducting mediation by such experts as may be nominated by the mediation cell, and it shall be obligatory for them to attend such training. Disqualifications for empanelment as mediator. A person who has been adjudged as insolvent, a person against whom criminal charges involving moral turpitude are framed by a criminal court and are pending, a person who has been convicted by a criminal court for any offence involving moral turpitude, a person against whom disciplinary proceedings have been initiated by the appropriate disciplinary authority and are pending or have resulted in a punishment. Apart from this, a person who is interested or connected with the subject matter of a consumer dispute or is related to or has been associated or connected in any manner, including in a professional capacity, with any of the parties to the consumer dispute or any of their associates, affiliates, promoters, holding companies, subsidiaries, partners, directors or employees shall be disqualified for being nominated as mediator in that particular case. Duty of disclosure on mediator. It shall be the duty of the mediator to disclose any personal, professional or financial interest in the outcome of the consumer dispute. The circumstances which may give rise to a justifiable doubt as to his independence or impartiality shall also be mentioned to the parties. In certain cases where the district commission or the state commission or the national commission is satisfied on the information supplied by the mediator or on the information received from any other person, and after hearing the mediator shall replace such mediator by another mediator. Code of conduct of mediator. The empanelled mediators shall not communicate directly or indirectly with any of the parties or their associates, affiliates, promoters, etc., or with any of their counsel during the pendency of the mediation proceedings, except during the course of the mediation in the presence of the parties or their counsel. The mediator also shall not accept any gift or hospitality from any of the parties or their associates, affiliates or promoters, as the case may be. Further, the mediator shall attempt to facilitate a voluntary resolution of the disputes between the parties and assist them in removing misunderstandings and generating options to resolve their disputes. However, the mediator shall not impose any term or any settlement upon the parties. The mediator shall explain the terms of the agreement to the parties before obtaining their respective signatures on it. The parties and the mediator shall maintain confidentiality in respect of the events that transpire during the mediation proceedings and shall not use or rely upon any information, document, etc., that is produced, the proposals and admissions made, or the views expressed during the mediation proceedings. There shall be also no audio or video recording of the mediation proceedings. Apart from this, no mediator shall be liable for any civil or criminal proceedings for any act done bona fidely by him in his capacity as a mediator. This provides immunity to the mediator. The mediator shall not be summoned by a party to appear in a court or other forum to testify in regard to any information that is received or any action that is taken by him during the mediation proceedings. The mediation proceedings shall be conducted in the presence of the parties or their authorized representatives or counsel, and shall stand terminated on the expiry of 3 months from the date of first appearance before the mediator, unless the time for completion of mediation is extended by the Consumer Commission. The parties shall be entitled to appear before the mediator in person or through their respective counsel or authorized representatives. The mediator shall be guided by the principles of natural justice and fair play, but shall not be bound by the provisions of Code of Civil Procedure and the Indian Evidence Act. Further, the parties shall provide all such information to the mediator as may be reasonably required by him for conducting the mediation proceedings. The record of the proceedings shall be prepared by the mediator on every date and shall be signed by the parties or their counsel, authorized representatives or attorneys. The agreement executed between the parties shall be submitted by the mediator to the Consumer Commission in a sealed cover with a forwarding letter. However, if no agreement is executed between the parties within the time prescribed, the mediator shall intimate to the Consumer Commission without in any manner disclosing as to what transpired during the mediation proceedings, what was the stand taken by the parties, or why the agreement could not be reached. Removal of mediator. If a mediator is discovered to be disqualified or he is in any manner misconducting himself as a mediator, or he is otherwise found unsuitable to continue as a mediator, the mediation cell may remove his name from the panel of mediators. However, an opportunity of being heard shall be provided to him. Fee of mediators. A consolidated fee in a successful mediation shall be paid to the mediator who conducts the mediation proceedings from the time of reference till their conclusion. The fee of the mediator empanelled with a Consumer Commission, including costs of secretarial assistance and other ancillary expenses, shall be fixed by the President of the respective Consumer Commission. Considering the nature of the dispute. In an unsuccessful mediation, half of the aforesaid fees will be paid to the mediator. The fee of the mediator shall be shared equally by the two sets of parties. The mediator who successfully conducts part of the proceedings will be paid such fees as may be fixed by the President of the Consumer Commission. The fee shall be deposited in advance with the mediation cell, and if a party does not deposit his share of the fees or the cost of the mediation, the Consumer Commission may, on the application of the mediator or any other party, direct the party in default to deposit the same within a week, and if he fails to deposit such fees, the Consumer Commission may permit the other parties to deposit the same and recover the amount from the defaulting party. However, if the fee is not deposited, the Consumer Commission may terminate the mediation proceedings. Procedure for mediation. The mediation shall be held in the Consumer Mediation Cell attached to the District Commission. the State Commission or the National Commission. Where a consumer dispute is referred for mediation by the Commission, the mediator nominated by such Commission shall have regard to the rights and obligations of the parties, the usages of trade if any, the circumstances giving rise to the consumer dispute and other relevant factors as he may deem necessary, and shall be guided by the principles of natural justice while carrying out the mediation. Now, let us look at the important aspect of settlement through mediation. Pursuant to mediation, if an agreement is reached between the parties with respect to all of the issues involved in the consumer dispute or with respect to only some of the issues, the terms of such agreement shall be reduced to writing and signed by the parties to such dispute or by their authorized representatives. The mediator shall prepare a settlement report of the settlement and forward the signed agreement along with such report to the concerned commission. In case of settlement by mediation, the complainant shall be entitled to receive full amount of application fees paid in respect of such complaint. Further, a settlement agreement shall not be discharged by the death of any party and shall be enforceable by or against the legal representative of the deceased party. Where no agreement is reached between the parties within the specified time, or the mediator is of the opinion that settlement is not possible, he shall prepare his report accordingly and submit the same to the concerned commission. Recording settlement and passing of the order. The district commission or the state commission or the national commission shall within 7 days of the receipt of the settlement report pass suitable order recording such settlement of consumer dispute and dispose of the matter accordingly. Where the consumer dispute is settled only in part, the commission shall record settlement of issues which have been so settled and continue to hear other issues involved in such consumer dispute. Where the consumer dispute could not be settled by mediation, the commission shall continue to hear all the issues involved in such consumer dispute. Dear viewers, I hope you have understood the significance of mediation and its procedure with respect to consumer disputes in India. We will meet again in the next lesson. Thank you.